Is Insurance Regulation 187 unconstitutionally vague and an improper policy? To find out, you have to read Independent Insurance Agents versus New York State Department of Financial Services. It's only 20 pages. Don't have time for that? I got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases in 5 minutes or less if I can do it. The episode on Independent Insurance Agents and Brokers of New York versus New York State Department of Financial Services. This can be found at 2022 New York Slip Opinion 05917, published by the Court of Appeals on October 20th, 2022. The issue in this case is whether or not an administrative agency, the Department of Financial Services, whether their regulation number 187 is unconstitutionally vague and therefore invalid. This regulation can be found at 11 NYCRR, Part 225. Before we get into what the facts are here with the statute and what the regulation is, let's talk about what it means to be unconstitutionally vague. The law in this case says that a rule is unconstitutionally vague if it fails to provide a person of ordinary intelligence with reasonable opportunity to know what's prohibited, and if it's written in a way that permits or encourages arbitrary or discriminatory enforcement. Basically, there's a two-part test. The two-part test is this. Is it sufficiently definite? Is the regulation definite enough to give a person of ordinary intelligence fair notice that the conduct is forbidden? So, is it sufficient warning to an individual? And secondly, does it provide sufficient information to officials such that there's a clear standard of enforcement? So is there guidance for officials? Does it provide sufficient warning to the individual? And does it provide sufficient guidance for regulation officials to determine whether someone broke the rule? That's the two-part test. Now, let's talk about what the actual law is here. This is Insurance Regulation 187. It was first enacted as an emergency in 2010. Then 2013, it was finally made part of the permanent rules. And in 2018, it was amended in the way that it's being challenged right now. Basically, what this rule is, it was designed to protect consumers, the public, like you and me, from unsavory producers and sellers of life insurance and annuities. Basically, life insurance and annuities have become so complex, and there's a market where they give incentives to providers and to sellers of insurance that would incentivize them to give bad insurance or bad annuities to a consumer because they get the incentives. They get paid by the creators of some policies. Not all, obviously, just some, enough that it's sufficient to make this rule. And basically, the rule says, this new amended rule 187 says that a producer or insurer who's going to recommend a policy, a life insurance policy or an annuity to a consumer, when recommending a product, must, number one, make a reasonable effort to get the consumer's suitability information. It shouldn't be that the same product is the best product for every single person that they see. Age, income, all the demographic information that would help determine what the right policy is, they have to try and get it. Number two, base a recommendation on an evaluation of that suitability information. Number three, only consider the interest of the consumer in terms of the recommendation, not the incentives or compensation that they're going to get. Number four, only recommend suitable transactions, suitable policies. Number five, have a reasonable basis to believe that the consumer has been reasonably informed about the features of the policy. And number six, that the consumer would benefit from the policy as a whole and from individual features. Okay, so that's the regulation. Basically, it's to protect the consumer. So what happens is the Independent Insurance Agents and Brokers of New York challenge this rule and say it's vague. They say it's vague because the terms are not sufficiently clear. The term recommendation is not clear. The term suitability information is not clear. The term best interest is not clear. The Court of Appeals goes through this and says, no, it's not vague. Then the Court of Appeals says, well, there's three additional arguments they're making. That the Department of Financial Services, DFS, exceeded its authority to even issue this regulation. And they say, nope, that's not true. It's allowed to, an agency is allowed to engage in administrative rulemaking, but not allowed to engage in legislative policy making. And because they're doing, and basically the Court of Appeal says they're not doing the legislative policy making, they're just making rules to enact their own already existing rules. So they kick that. They also address the issue raised that the State Administrative Procedures Act has not been followed. Court of Appeal says, nope, not true. DFS, in fact, did do they gave a sufficient best estimate as to what the regulation would cost. They gave a sufficient explanation between the federal standard and the New York standard, and they considered lesser approaches and how it would impact small businesses. And finally, they addressed the issue raised that it's arbitrary and irrational, and the Court of Appeal says, no, it's not. As long as it's a genuinely reasonable and rational policy, it's okay. The courts are not supposed to consider the merits of the policy. They're not supposed to consider the policy considerations. They're just supposed to consider whether there's any reasonable reason why this regulation was drafted, and they say that the record is sufficient to make this a regulation, and it's therefore not arbitrary and irrational. So all the challenges are disposed of by the Court of Appeals. Insurance Regulation 187 stands. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.